A very warm welcome to my YouTube channel. Let's know law. Myself, Maninderjeet Kaur Boparai. Today I am going to discuss a very important judgment with you all, that is GURBAKSH, SINGH, SIBBIA and other versus State of Punjab. It was delivered in year 1980. The bench in this judgment comprises of Justice Chief Justice Y.V. Chandrachud, Justice P.N. Bhagwati, Justice N.L. Unantwalia, Justice R.S. Pathak, Justice O. Chinnappa Reddy. So, in the petitioner side, there were GURBAKSH, SINGH, SIBBIA and another persons, and in the respondent side, there was State of Punjab. This judgment delivered on 9th April 1980. So this judgment deals with anticipatory bail. Section 438 of the Code of Criminal Procedure 1973 and has explained the scope of judicial balancing of personal liberty and the investigational power of the police. As such, the term anticipatory bail has not been mentioned anywhere in any of the Indian legislations. This case in particular is extremely essential as a constitutional bench laid down 8 guidelines to be followed by the High Courts and Sessions Court while exercising their discretionary powers to grant or reject anticipatory bails. In this judgment, Section 437 and 438 are involved. These sections of the code consist of provisions regarding grant of bail to a person apprehending an arrest. So, according to Section 437, a person may be released on bail if he has been detained without a warrant for the suspicion of commission of a non-bailable offence, and if the court or the investigating officer do not find a reasonable ground for believing that the suspect has committed a non-bailable offence but find ground for further inquiry into his guilt. The clauses have certain riders attached to them which ascertain the circumstances in which the bail must not be granted. Further, under Section 438, Section 438 provides provisions regarding, first of all, who can apply for anticipatory bail, who is to be applied to, what are the conditions that must be considered while granting an anticipatory bail, and who can grant bail in specific circumstances. So Section 438 deals with these questions and answer these questions. So according to this section, a person who apprehends arrest on suspicion or accusation of commission of a non-bailable offence may apply for anticipatory bail to the High Court or the Sessions Court. Next, I am going to discuss the facts of the case. That is, the appellant herein, Shri GURBAKSH Singh SIBBIA, was a Minister of Irrigation and Power in the Congress Ministry of the Government of Punjab. Grave allegations of political corruptions were made against him and others, whereupon applications were filed in the High Court of Punjab and Haryana under Section 438 of the Criminal Procedure Code, praying that the appellants be directed to be released on bail in the event of their arrest on the aforesaid charges. So, in the High Court, appellants made some arguments. The appellants in the High Court trial contended that the appellant Mr. GURBAKSH Singh SIBBIA and others were men of substance and held high positions in the Punjab Ministry and were unlikely to abscond or avoid facing the trial. Thus, they must be granted anticipatory bail. Single judge of High Court had referred the application to a full bench. Applicant's first argument, which states Applicants were men of substance and held high positions in the Punjab ministry and were likely to abscond or avoid facing the trial were rejected by the full bench of High Court on account of negation of equality in considering the position and status of the party and or individual while granting an anticipatory bail. According to the full bench, this contention was illogical and aggravating. Full bench of High Court further laid down certain contentions and held that the power under Section 438 Criminal Procedure Code is of an extraordinary character and must be exercised sparingly in exceptional cases only. Second, neither Section 438 nor any other provision of the code authorizes the grant of blanket anticipatory bail for offences not yet committed or with regard to acquisition not so far levelled. Third, the full bench of High Court considered that the said bar is not unguided but all the limitations imposed in the preceding section 437 are implicit therein and must be read into section 438. In addition to the limitations mentioned in section 437, the petitioner must make out a special case for the exercise of the power to grant anticipatory bail, where a legitimate case for the remand of the offender to the police custody under section 167 subsection 2 can be made out by the investigating agency or reasonable claim to secure incriminating material from information likely to be received from the offender under section 27 of the Evidence Act can be made out. The power under section 438 should not be exercised. Further, the full bench of High Court contended that the discretion under section 438 cannot be exercised with regard to offences punishable with death or imprisonment for life unless the court at that very stage is satisfied that such a charge appears to be false or groundless. Seventhly, the larger interest of the public and state demand that in serious cases like economic offences involving blatant corruption at the higher rungs of the executive and political power, the discretion under section 438 of the code should not be exercised. And in the last, the full bench of the High Court said mere general allegations of malafide in the petition are inadequate. The court must be satisfied on materials before it that the allegations of malafide are substantial and the accusation appears to be false and groundless. Then the application was dismissed by the full bench of the High Court, but on special leave to appeal, the application was allowed by the Supreme Court. The appellants in their appeal to the Supreme Court contended that the power conferred by section 438 of the Code on the High Court or Sessions Court to grant anticipatory bail is not necessarily limited to the circumstances or contingencies as summarized by the full bench of the High Court. Secondly, the concerned court must have the discretion to grant anticipatory bail depending upon the circumstances and effects of that particular case. Thirdly, the denial of bail amounts to deprivation or violation of right to life and personal liberty. Thus, the court should lean away from the imposition of restrictions that are not needed in regard to the provision of section 438 when there are no such restriction laid down by the legislature in that section itself. Further, the appellants contended that section 438 provides for the procedure of granting of anticipatory bail. It is concerned with the right to life and personal liberty of an individual who is yet to be found guilty in the commission of a non-bailable offence. Thus, the section and its provisions must be tested to examine their fairness. Imposition of unreasonable ground must also be taken into account while determining the scope of section 438. Lastly, if the court imposes an unfair restriction on the individual's right to obtain an anticipatory bail, it would be violative of Article 21 and is liable to be struck down. So these were the contentions later presented by the appellants in the Supreme Court. So many facts and issues were raised in the Supreme Court and decided by, and these were in the sequence. The first one fact and issue was whether the power conferred by Section 438 of the Code on the High Court or Sessions Court to grant anticipatory bail is necessarily limited to the circumstances or contingencies as summarized by the full bench of the High Court. Secondly, whether the concerned court must have the discretion to grant anticipatory bail depending upon the circumstances and effects of that particular case. Third, whether the denial of bail amounts to deprivation or violation of right to life and personal liberty under Article 21 of the Constitution. And fourth and the last one, whether the court should lean away from the imposition of restrictions that are not needed in regard to the provision of Section 438 when there are no such restrictions laid down by the legislature in that section itself. In the end, the Supreme Court held that the discretion of granting anticipatory bail must be used more objectively, and the higher courts have the power to correct this discretion if the need arises. A dual protection has been provided to this system so that there is no misuse if the discretion and the process. The Constitutional Bench set aside the judgment of the full bench and laid down the further guidelines for exercising discretionary power while granting or not granting anticipatory bail. First guideline was the power, though of extraordinary character, does not justify its use in exceptional cases. Due care, caution, and circumspection must be used while exercising such power. Secondly, the individual applying for anticipatory bail must have a reasonable apprehension of getting arrested for a non-bailable offence, which can be objectively examined by the court. The third guideline was that anticipatory bail must not be denied in cases where the accused is suspected to have committed an offence punishable in the form of death penalty or life imprisonment, unless the court has sufficient evidence before it to justify the refusal. Next, the blanket or protective orders of bail should not be passed. Also, for efficient investigation, certain conditions can be imposed under Section 438 subsection 2, such as on discovery of a material or evidence in regard to the case. The fifth guideline was that the filing of FIR is not a condition precedent to the grant of anticipatory bail under Section 438, and the individual can be granted bail as long as no arrest has been made. The sixth guideline was that the provisions under Section 438 cannot be invoked after the arrest has been made. In the seventh guideline, the Supreme Court held that under Section 438, interim bail order can be passed without issuing a notice to the public prosecutor, but it should be mandatorily issued to him afterwards. The court has the discretionary powers to impose suitable conditions in case of such interim bails. In the last, the Supreme Court has held that the court has a power to limit the operation of anticipatory bail orders until after the FIR is filed. The applicant may be asked to obtain a bail order under Section 437 or 439 of the CRPC after the filing of FIR has taken place. So, the judgment of the full bench of the Punjab and Haryana High Court, which was treated as a main case under appeal, was substantially set aside, and this appeal partially allowed by the Supreme Court with so many guidelines. So this was all about the judgment, that is. And if you like, please like and subscribe my YouTube channel Let's Know Law, and please press the bell icon for more videos, and thank you so much.